Collins Irby versus Irby, 251-12-142. I've got several motions by various defendants to dismiss, stay, or transfer. We'll call that the first motion, although it seems like several defendants filed one, and then we've got one defendant filed a motion to stay scope, and then we've got the plaintiff's motion to amend. Let's take up the motions to dismiss first. So, who filed the first motion to dismiss?
May it please the court, I'm Steve Williams, and I represent three of the defendants. If mine wasn't the first motion, it was pretty close to it. It's on the same day.
Okay. So we'll in my sense, is go ahead and start with this motion. Any objection to that, Bill?
Yes, I think, Your Honor, the order of the hearing of the motions is important in this case because the motion believed to amend the complaint, if granted, would move the motions to stay and transfer.
What to say?
We don't agree with that, Your Honor. That motion was noticed for hearing today by notice last Friday. So it's not a timely notice to hear that motion, but I can address that in my argument on our motion to transfer or dismiss, which it's not going to make any difference.
Well, I will no doubt take all three of the motions under advisement so that the order that they're presented isn't necessarily important. Go ahead.
We filed a notice of dismissal of certain claim and under Rule 41, and we dismissed tortious interference with the inheritance claim, which is the substance of 90% or more for the defendant's motion. We also dismissed the claim against the conservators in their capacity as a conservator. So with that, there are no claims that we state here today for tortious interference. There's no claims against the conservators in their capacity as a conservator there. So therefore, there's no basis for transfer to transfer court. No, there's a basis for motion to dismiss. So I do think if the court is review the notice of dismissal, then their motions are being approved.
Let's, I'm sure we've all got various arguments to make, and we need to get started. So let's get started on the motions to dismiss, stay, or transfer. And I'll tell you, going into it, I will likely take everything under advisement. So let's go ahead and get started. Mr. Williams.
Thank you, Your Honor. May it please the court again, I'm Steve Williams, along with Buddy McRae in my office. We represent three of the 10 defendants in this case. The three represented by us are Mr. Charles Irby, who is brother of Stuart M. Irby. Charles Irby lives in Nashville, Tennessee. We also represent Joe Irby, who's another brother to Stuart Irby, who lives in Little Rock, Arkansas. And finally, we represent Stuart M. Irby, Jr., who is the son of Stuart Irby. And he also lives in Little Rock. Our motion to dismiss, transfer, or stay raises a legal question concerning the jurisdiction of the circuit court to hear this case. I know, Your Honor, there's been a lot of history and a lot of newspaper reporting concerning previous litigation involving Karen Irby and Stuart Irby. I would say at the outset that I've not been involved in any of that previous litigation. This is the first involvement I've had in any of these claims. And on my first reading of the complaint that was filed here in circuit court, I had to wonder why it was even in circuit court. The complaint addresses claims about Stuart Irby's will. It addresses claims about Mr. Irby's estate. It has claims relating to the conservatorship of Stuart M. Irby, and I would point out that all three of the defendants I represent at one time or another served as conservator for Mr. Stuart Irby, and two of the other defendants in the case that I do not represent also served as conservators. So you got 5 conservator defendants in this case. And there are allegations in this complaint concerning Karen Irby, now Karen Collins' divorce from Stuart Irby. All of these Chancery Court matters. And as I read that complaint, I wondered why it was here. It sounded like a will contest. It sounded like a dispute about conservatorship matters that were handled in Chancery Court. It sounded in matters relating to their divorce. After doing some study of the procedure and the background, Your Honor, what I discovered was what I call a tangled web of litigation that this plaintiff has filed. In our brief to the court, on pages 2, 3, and 4, we list a good bit of the historical background of these parties, Stuart Irby and Karen Irby, Your Honor, along with a lot of the procedural background. I want to emphasize 5 of those historical and procedural facts.
All right, and before you dive too far into those, I want everybody to realize that I've read everything that you filed, so I'm well familiar with your briefs, motions, responses, and your arguments. So go ahead.
Thank you, Your Honor. Having read those things, you know that the divorce was finalized in Hinds County Chancery Court on December the 12th of 2011. On January the 10th of this year, Karen Irby's 18-year suspendence for culpable negligent homicide was commuted by the governor. And Stuart M. Irby died a week later on January the 17th, 2012. The first procedural point in the litigation that underlies this lawsuit, Your Honor, was that the plaintiff, Ms. Collins, filed a will contest in Hinds County Chancery Court on February the 14th, 2012, less than a month after Mr. Irby died. 10 days, Your Honor, before they filed this circuit court case. And I would point out for the court's information that that will contest is set for trial in February of next year before Chancellor Thomas. The next procedural fact, Your Honor, that I would offer to the court for its consideration is the fact that Ms. Collins also filed a petition in the Hinds County Chancery Court to invalidate.
Let me ask you, you said set for trial next year. Is it scheduling order in place?
I don't know of a scheduling order, Your Honor. I just know the date has been firmed up, is my understanding.
All right, I'll let the plaintiff address that. Go ahead.
Thank you, Your Honor. The plaintiff in this case also filed a petition in Hinds County Chancery Court to invalidate Stuart Irby's conservatorship, seeking an accounting of transactions in that conservatorship. That petition, Your Honor, was filed on March the 12th of this year, and that was filed less than 30 days after this lawsuit was filed. So what we have, Your Honor, is no less than 2 Hinds County Chancery Court lawsuits that are in progress, the will contest, petition attacking the conservatorship, and 1 Hinds County Chancery Court lawsuit that's proceeded through judgment. That's the divorce case without any appeal, and this circuit court lawsuit. So there are 4 separate proceedings, Your Honor, that in our view are all intertwined and related because they're all based on the same operative facts.
Who has the other than Judge Thomas, who has the second Chancery lawsuit assigned?
Judge Thomas, I'm advised, Your Honor, has the conservatorship proceeding. Judge Singletary handled the divorce.
All right, go ahead.
What we, as you know, Your Honor, from our brief, what we have relied on are provisions of the Mississippi Constitution, Mississippi statutes, and various case law relating to the jurisdictional question between Chancery Court and Circuit Court. Article 6, Section 159 of the Constitution makes it clear that the Chancery Court has full jurisdiction of matters relating to testamentary matters, administration of estates, That same constitutional provision gives the Chancery Court full jurisdiction over divorce and alimony, anything related to divorce. Section 11-5-1 of our code provides that suits against guardians, which has been interpreted to involve any suit relating to conservatorships, shall be brought in Chancery Court. The primary case, and we've cited a number of cases, Your Honor, in our brief, as you know, because we think this is so clear. There's just a legion of cases that support our position. But the primary case that I would offer to the court for your consideration is the Trustmark versus Johnson Supreme Court case that was decided by the Mississippi Supreme Court in 2004. That case, Your Honor, is reported at 865 Southern 2nd, 1148. That case, Your Honor, involved a claim relating to a trust, another Chancery Court jurisdiction matter, of a Mrs. Beatonhorn in Vicksburg. And the trust provided that she put her assets in a trust. The beneficiaries of the trust were Milton Beatonhorn and his children. And Trustmark Bank, or at least his predecessor, was named as trustee of the trust to administer it. When Ms. Beatonhorn died, assets went to Mr. Beatonhorn and the children in equal shares. On his death, then the trust assets went to the children. Ms. Beatonhorn died, her estate was administered, and the trust was administered to Chancery Court in Warren County. Mr. Beatonhorn lived for several more years. He was a businessman of some sort. He borrowed a large sum of money from Trustmark Bank. And when he finally died, there weren't any assets apparently left to be distributed to the children. They filed a lawsuit in Hinds County Circuit Court, alleging that the trustee had mismanaged the funds, had committed torts, breach of trust in Circuit Court. The bank moved to have the case transferred to Chancery Court. And the Circuit Court denied that request, but the case went up on interlocutory appeal. And the Supreme Court held that the case should have been transferred to Warren County because of those same constitutional provisions and statutory provisions that we've cited in our brief. And I would point out, too, that Mr. Sweet, who's one of the plaintiff's attorneys in this case, was at least reported as being involved in that case on the appeal. Whether he was involved at the trial level or not, I don't know.
Was there a pending chancery action in that case prior to the lawsuit being filed in Hinds County?
I don't know if that estate was still open or not, Your Honor. I don't know that the case detail reports that. I do know that Mr. Beatonhorn had an estate pending in another county, in another Chancery Court, and that case was stayed pending the result of the Hinds County Circuit Court case, is my understanding. There are three things that the Supreme Court said in the Trustmark case, Your Honor, that I would offer to you as being important to your decision in this case. First, they cited Article 6, Section 157 of the Mississippi Constitution, which says, quote, all causes that may be brought in the Circuit Court whereof the Chancery Court has exclusive jurisdiction shall be transferred to the Chancery Court. The second point they made in that decision, Your Honor, had to do with comparing the substance of the complaint in Circuit Court with the forms. In other words, you can call a claim or a count whatever you want to call it. You can call it a tort or a legal cause of action. But the court said, look at the substance of the complaint and what it provides. There they said the following, Your Honor, quote, plaintiffs counter that they seek legal action rather than equitable remedies, and that subject matter jurisdiction is proper in the Circuit Court. However, the plaintiffs concede that when determining the true nature of the claim, one must look at the substance and not the form of the claim in order to determine whether the claim is legal or equitable. Unquote. And finally, the third thing they said, Your Honor, they said this case was analogous to a decision that the Supreme Court had made in 2002 in the case of Rogers versus Eves. That's reported in 812 Southern 2nd, 208. Your Honor, the Rogers versus Eves case arose from a divorce that was in Scott County Chancery Court. The Eves law firm was representing the wife in the divorce case. And at some point during the proceedings in the divorce case, the Eves firm was relieved of its duties and replaced by another lawyer. That case went on, ended in irreconcilable differences, divorce, and then it had some protracted litigation with respect to child custody, which had a trial for some 15 days or more, and ended up with a decision from the chancellor in that case. What happened is the wife filed a circuit court malpractice lawsuit against the Eves law firm in Madison County Circuit Court. Straight up legal malpractice claim relating to the divorce. The Eves law firm moved to have the case transferred to Scott County Chancery Court. The Madison Circuit Judge transferred it. The Mississippi Supreme Court approved that transfer on the same basis that the court approved the transfer to the Trustmark case. Now, it cited the fact that even if there are legal claims made in the circuit court action, the Chancery Court has pendant jurisdiction under Section 9-5-81, which provides, Your Honor, quote, Chancery Court, in addition to the full jurisdiction in all the matters and cases expressly conferred upon it by the Constitution, shall have jurisdiction of all cases transferred to it by the Circuit Court or remanded to it by the Supreme Court, and such further jurisdiction as is in this chapter or elsewhere provided by law, unquote. So the Chancery Court can grant legal relief. We've cited a number of cases in our brief that go through that in some detail. Our position is, Your Honor, the Chancery Court in this case, in this situation, based on the operative facts underlying this complaint, has primary jurisdiction over this case, has pendant jurisdiction over any matters relating to estates, conservatorships, divorce proceedings. And in our view, let me back up and say, there is no responsive or reply brief to the brief we have filed on this, Your Honor. So I assume, therefore, the respondents don't dispute any of the case law or any of the statutes or the constitutional provisions we cite. Now that they have read it and digested it, they attempted procedurally to remove those things from the case that they think are equitable in nature, leaving only some legal claim. Our position is, Your Honor, based on the Rogers versus Eves case, based on the Trustmark case, there is no way that bell can be unrung. You can't separate the facts that underlie this case and the claims in this case from the same claims that are being made in Chancery Court right now by the same plaintiff. So in our position, for purposes of doing the right thing here, this case should be transferred. And there was one more quote, Your Honor, and I'll end with this. This comes from the Trustmark case at page 1153. The Mississippi Supreme Court said this, quote, our citizens who become litigants in our state trial courts are entitled to be assured early on in the life of the litigation that they are in the right court. Interlocutory appeals, or even worse, a trial on the merits in the wrong court, are costly and time-consuming, unquote. We filed the motion for the stay of discovery in this case, Your Honor, for that very reason. We didn't think until this court made a decision on the jurisdiction question that the parties should be put to the expense of extensive and expensive discovery. There have been a number of motions already filed in this court and argued, so there's been expense mounting in this case already. Based on those two cases, the Trustmark case and the Rogers case, we think this case should be transferred to Chancery Court, and that would be a proper decision for your Honor to make. Thank you, Judge.
All right, I'll be giving you an opportunity to reply. We do have other defendants filing motions. Tell me again who you are.
Clifford Andrews, Your Honor.
All right, and who do you represent, Mr. Ray?
Dr. Maticasera and Sycamore.
All right. Go ahead.
The thrust of our argument today, Your Honor, is one change of venue. While I adopt what Mr. Williams told you about transfer and stay, we are in a very unique situation. Dr. Maticasera was Mr. Irby's psychiatrist, and the complaint itself speaks for itself as to all the allegations which are alleged against Dr. Maticasera and what he's saying. Under 12b3, this matter must be transferred to Rankin County. As the affidavit attached to our motion described, Dr. Maticasera performed all of his counseling, all of the psychiatric examinations in Flowood, Mississippi. He was definitely in Rankin County when any actions as alleged in the complaint took place. Just as Mr. Williams told you, there is no response to our motion. As a matter of fact, even filing on Friday, their motion to amend the complaint has no consequence as far as the venue is concerned. The Mississippi Supreme Court has stated unequivocally that proper venue is determined at the time the lawsuit is originally filed. Unfortunately, in our brief, because we never got a response, there was actually no time for us to add that, and I'd like to approach the bench if I could and handle these two cases.
Have you got a copy for the plaintiff?
I do not, but I can get them signed, Your Honor.
All right.
Austin versus Well, 919 Southern 2nd, 961. And Crenshaw versus Roman, 942 Southern 2nd, 806. But as the court can see from these cases,
And if you would, make sure that you get to them the same highlighted portions that you gave to me.
I will, Your Honor.
Do you know what those are?
I do. As a matter of fact, I can just give them my copies.
All right, please.
I'll even turn to the same page.
All right.
So it doesn't matter that they attempt to amend their complaint at a late hour, Your Honor, because venue was fixed at the time they filed their original complaint back in February 24, 2012. Obviously, the basis of our venue change is the new healthcare statutes on venue. This is as strong a venue statute as I've ever seen. In law school, we had a professor who used to discuss it as jurisdictional in nature. This is as strong as that discussion back then. Section 11.11.3.3 mandates any action against a licensed physician or legal entity, which here is Sycamore, which may be liable for malpractice. And the courts define malpractice as legal fault, negligence, error, omission, mistake, breach of standard of care, or unauthorized rendering of professional services. The legislature did not stop at malpractice or medical negligence. They added all the other areas covering any action, and that's what it says, any action against a medical professional or legal entity, again, Sycamore, shall be brought in the county in which the act occurred. Dr. Maticasera is a psychiatrist. Again, our affidavit to the motion shows everything took place in Rankin County as far as his treatment is concerned. Adams versus Baptist Memorial Hospital of DeSoto says only proper venue against a medical provider is in the county in which the alleged acts occur. It cannot be any clearer than that. Plaintiff's complaint has 7 counts. The original complaint. Page 22 of the complaint. Plaintiff's allegations are that Dr. Matthew was Mr. Irby's psychiatrist and reported he had severe brain injury and was non-compos mentis. In paragraph 34, plaintiffs allege Dr. Matthew noted that Mr. Irby was bothered by the demise of his marriage and the stress of it could trigger more depression and suicidal thoughts. Dr. Matthew was not an orthopedic surgeon who treated Mr. Irby for broken bones and said, oh wait, you need to get a divorce or I need to treat you for suicide. Dr. Matthew was not a pulmonologist who was treating him for lung problems. The point here, Your Honor, is that Dr. Matthew was a psychiatrist who was treating him for psychological problems. There is no way to change or unmesh everything that they have alleged into their accounts in discussing negligence. One word is enough to send this to Rankin County for Dr. Matthew or Sycamore. They allege Sycamore is negligent for the actions of those over which it would have control. Again, Dr. Matthew.
In your petition for relief, are you looking for a transfer? You say Rankin County, are you looking for a transfer to Rankin Chancery or Circuit?
Well, I think properly I would have to go to circuit court in Rankin County.
Go ahead.
And the court may sever and send me. I think it has to do that at the very least. And frankly, in looking at other cases in the state of Mississippi, all the defendants can go. So I had raised a motion to dismiss as well for violation of the failure to notice. But in retrospect, Your Honor, I think venue is the primary target. And then when I get to Rankin County, I can argue that before the Rankin County Circuit Court. That court would then have jurisdiction to hear that matter. So with that, Your Honor, I'll close.
All right. Very well. Other defendants? Keep in mind, we've already plowed around. We don't necessarily need to replow. Sure. All right. Who are you with and who you represent?
Your Honor, I'm Kathleen O'Byrne, and along with Wayne Drinkwater, our firm Bradley Arian represents Cal Wells, Richard Montague, and the Wellsmore firm. And we also have pending before the court today a motion to dismiss, stay, or transfer. I certainly do not want to reiterate what Mr. Williams has already argued, but I do want to make the point, Your Honor, that the plaintiff at this point has all but conceded our motion. She has not filed any response to our motion to dismiss, stay, or transfer. The rules require a response within 10 days. Because we haven't gotten a response, I'd like to reserve our right to file any reply brief that may be necessary once we hear what the plaintiff's arguments actually are. But aside from not filing any response to our motion, she has already filed this will contest and this petition to invalidate the conservatorship, effectively conceding that yes, that is the Chancery Court is the court that has jurisdiction over these matters. And then finally, Your Honor, with respect to the Rule 41 dismissal and the motion to amend, which I would like to reserve argument on once you take up that motion, Your Honor. That motion and that Rule 41 dismissal are also further evidence that they all but concede our motion because they're seeking to get rid of the testamentary claims and the conservatorship claims that form the basis of our motion to dismiss. So for those reasons, we also ask that the motion to transfer to Chancery Court be granted.
All right. Other defendants?
May it please the court, I'm Tom Gary. I represent Jeff Rickles.
Okay.
And I filed a motion to dismiss or to transfer or stay on May 1st, 2012, and joined the arguments of the other defendants and adopted them. And I don't need to plow any ground for the court that hasn't been spoken about already, but I did want to tell the court who Jeff Rickles is. He's a vice president of Pinnacle Trust. He was a conservator, and he appeared over in Chancery Court in the conservatorship matter, and with other conservators got permission to join in the divorce proceeding that Stuart Irby had filed, and then participated in the divorce proceeding and supported the divorce. And if this court keeps this case, this court and the jury will be asked to second guess what Mr. Rickles did over in the Chancery Court. And that's a collateral attack on proceedings in other courts. And I think that's improper. And that's why, whether we're talking about the original complaint or the amended complaint, that's why these matters need to go across the street. That's where they belong. Thank you.
Any other defendant know Ms. Corbin, you represent Rickles, is that correct?
Yes, Your Honor. We had no further argument.
Thank you. All right. Any other defendant? Ms. Drinkwater, who do you represent?
I'm with Ms. O'Byrne today, and she has spoken for us.
All right. Very well. All right. Now, what's that plaintiff on the motions to dismiss, state, or transfer?
Judge, again, Terry Harris. They made a big deal about the plaintiff did not respond to their motion to dismiss. Actually, the plaintiff did respond to it by filing their notice of dismissal of certain claims. In this case, we voluntarily dismissed the tortious interference with the inheritance claim, as well as the individual claims against the conservators. That action in and of itself.
Let me ask you this. I just reviewed this notice of dismissal this morning. How about Mr. Annan's claims that sound medical negligence? Were those dismissed?
Well, Your Honor, there were some facts. To answer the question, no. There were some facts in the complaint that factually said who Dr. Medicacera is. But there's no claim against Dr. Medicacera for medical negligence. The statute in which he referred to deals with actions for medical malpractice.
Could you go to the podium? I'm a little hard to hear. That's got a microphone.
This is not an action for medical malpractice. The statute in which he refers deals with action against physicians who commit medical malpractice. If you take his argument, then it's really ridiculous if you think about it, because he's basically saying if a doctor has an accident, a car accident in Tupelo, then that doctor can only be sued here in Rankin County because that's where he is. That's not the case whatsoever. The statute, the 60-day notice only deals with medical negligence actions, not any other action. There are no claims against Dr. Medicacera for the course and scope of his services as a psychiatrist. The complaint did not allege that the original complaint or the proposed First Amendment complaint does not allege any causes of actions against Dr. Medicacera as a result of performing any type of evaluation of services on Stuart. So that's how I would address that, John. And back to, all of the defendants' motion to dismiss primarily deals with the tortious interference with the inheritance cause of action in which we had in complaint, as well as the claims against the conservators. Although we disagree, in which we argued here in the motion to intervene, the tortious interference with an inheritance cause of action is not a collateral attack on the will. We went back and forward with that, ad nauseum when we were here last time. Unfortunately, there are no Mississippi Supreme Court cases that addresses tortious interference with an inheritance. So as a result, we made the decision to just remove that cause of action altogether so that it won't cloud the issues in this case. And they refer to the will contest over in Chancery, the petition to invalidate the conservatorship over in Chancery. That has absolutely nothing to do with this cause of action. This is a alienation of affection claim against third parties. A will contest has absolutely nothing to do with alienation of affection claim. The petition to invalidate the conservatorship has absolutely nothing to do with an alienation of affection claim. As this court is well aware of, alienation of affection claim is a tort against a third party for destroying the marriage between two people. We have conspiracy claim in our complaint that has absolutely nothing to do with the will contest or the petition to invalidate the conservatorship. All the claims that were asserted in our complaint are circuit court causes of actions. Now, they had great arguments as it related to the tortious interference with the inheritance claim. If I were sitting in their shoes, I would have made the same arguments. Nevertheless, those claims aren't before this court anymore. They did not answer the complaint. They chose to file a motion to dismiss. Under Rule 41, we have the absolute right to dismiss those charges, those claims, prior to an answer being filed.
Why did you dismiss those claims?
Yeah, because I figured if this court would have ruled that we were allowed to stay here, we would have been going up to the Supreme Court. Rather than fight the appellate issue, we just decided to just dismiss our case. It's strong whether or not we have that cause of action or not. I think it's our duty to get Ms. Collins her day in court as quickly as we can get it. If we would not have dismissed it, and Your Honor would rule in our favor, we would have spent several months, not years, at the High Court.
All right. You didn't file a response articulating what you've articulated this morning. Is there a reason for that?
Well, Your Honor, when you drop the claims, then it makes it moot. So I think that it wasn't necessary. I filed a motion for leave to amend, and I referenced in the motion for leave to amend that removing those causes of action would do away with their claims. That's my reason for not filing a technical response. And we have a table full of defendants. That's hours and hours to draft responses to them. We just filed it in Rule 41. It does the same thing.
All right. Have you hit your high points?
Of course it does.
Yeah.
Finally, just to clarify, they made the argument that because a divorce was done over across the street in Chancery Court, this court should transfer the case over there because of alienation of affection. If that was the case, Your Honor, every alienation of affection claim would have to be in Chancery Court. And I think the court would just look at the law of the plethora of cases on alienation of affection, all dealing with cases that arose out of the circuit courts in our state.
All right.
Thank you, Your Honor.
Very well. Reply.
May it please the court, I assume you want to go in the same order with the defendants as we went previously. So
let's do that for the reply.
Briefly, Your Honor, I take a different view of this Rule 41 dismissal. I don't think it moves anything. I think that Rule 41 dismissal is a nullity because it doesn't fit the rule. I've looked to find cases that would allow this kind of conditional dismissal. Now, I understand what they're doing. They're not dismissing the whole case.
Let me ask you something procedurally before you head down that rabbit trail. Had any of the defendants filed an answer?
Yes, sir.
Okay. No.
Not all, only one, to my knowledge. I think that's correct. Was it for two? Dr. Madagusera and the psychiatrist's company filed answers. So two of the defendants filed an answer as well as a motion under Rule 12. So the other defendants, I believe all filed Rule 12 motions. But when you look at Rule 41, it's very clear about when the plaintiff has a, quote, absolute right to go file a notice of dismissal. Has to have certain conditions. Those conditions weren't met here. And, you know, it's difficult to understand how they drop some claims, retain others, and then on some of the defendants who they've sued personally and in their roles as conservators, they're going to leave them in the case personally and take off their conservatorship hat. Now, my source for saying this is a nullity is just to look no further than the comments to Rule 41. In the comments, it says this: the trial court has no power to impose terms and conditions if a plaintiff properly dismisses by notice under Rule 41A1.
Where are you reading that? Is it a comment?
Yes, sir. It's going to. It's the 9th paragraph. They're unnumbered, but it's the 9th paragraph under the comments. And after stating that rule concerning the unconditional right, where a plaintiff properly dismisses under 41A1, it says this, Your Honor: nor may the plaintiff seek to make a conditional dismissal under that portion of the rule. And if what the plaintiff filed in this case is not a conditional dismissal, I honestly don't know what is, Your Honor. Picking and choosing what they're going to take out of the case and the capacities in which they want to sue 5 of the defendants in this case. I'm back to the intertwined nature of the operative facts under this case. When counsel for the plaintiff says their claim for alienation of affection, they can maintain that against third parties. Well, excuse me. Some of these conservators were parties to the divorce. How do you undo that? How do you say their actions in the conservatorship as parties to the divorce is somehow creating alienation of affection? What he wants to do is take their hat off as conservator and somehow sue them individually, regardless of what they did in the conservatorship, regardless of the fact they were even parties in that case. So the Rule 41 dismissal is a nullity under the comments. And the other point is what they're doing on their motion to amend is to get this court to approve those dismissals by changing their complaint. And we say that's improper. The only authority this court needs to transfer this case to Chancery Court are the 2 cases we've already cited: the Eves case and the Trustmark case. Counsel for the plaintiff argues that what could be more of a legal action than a claim for alienation of affection? Well, my response would be, what could be more of a legal action than a malpractice lawsuit against lawyers? And the Supreme Court said, transfer to Chancery Court because it's related to what's going on in the Chancery Court. And that's where jurisdiction is proper. Thank you.
All right. May it please the court, I don't believe there's anything in the complaint about there being a car wreck, nor did I ever argue there was anything in the complaint about a car wreck. This is negligence. This goes beyond medical negligence. The legislature said it did not limit again to malpractice, negligence, omission, error. It says specifically, or unauthorized rendering of professional services. Their complaint is replete with allegations. Defendant Dr. Mathesera noted Stewart was bothered by the demise of his marriage and stress of it could trigger more depression and suicidal thoughts. Nonetheless, defendant Mathesera assisted co-defendants in prosecuting Stewart's divorce action. There's nothing here but allegations concerning how he acted as a psychiatrist. Thank you.
First, in reply to the plaintiff's argument, this motion to dismiss, stay, or transfer is before the court only based on the original complaint that the plaintiff filed. There is no amended complaint properly before the court for the court to consider in deciding on the motion to transfer. The Rule 41 notice of dismissal, the attempted dismissal of right of these individual claims and certain defendants in certain capacities is improper for a number of reasons that I'll get to in just a moment, Your Honor. But even if the amendments are allowed, even if these dismissals are allowed, still the amended complaint is rife with allegations that tie the remaining claims, the amended complaint, still to these Chancery Court matters. Your Honor can go through, and I'll be glad to, but in the interest of time, I won't. But still, there are allegations in the amended complaint that refer to the plaintiff's inheritance. They refer to control that the conservators allegedly had over Stuart Irby. And so for that reason, even if the court is considering the amended complaint, still the matter should be transferred to Chancery Court. With respect to the Rule 41 dismissal as of right, the plaintiff is not entitled to that dismissal. A plain reading of Rule 41A says it's a dismissal of an action, not an individual claim, not an individual defendant, not a defendant in a certain capacity. It's a dismissal of an action. So the dismissal as of right is not proper. Certainly the plaintiffs can move the court for a dismissal under Rule 41A2. But, Your Honor, I'd like to remind the court that the whole purpose of Rule 41, as stated in the comment, is to give the plaintiff the right to take a case out of court if no other party will be prejudiced. Well, here, Your Honor, all these defendants have already been prejudiced and will continue to be prejudiced if the court doesn't stop the gamesmanship that the plaintiffs have engaged in so far. 2 defendants have answered the complaint. All defendants have filed a motion to dismiss in some form or fashion. Other defendants have filed other motions. Some defendants have already responded to written discovery. All of the defendants responded to the motion for reassignment of this matter to Judge Kidd and attended a hearing before Your Honor. And clearly, if this legal maneuvering is not stopped at this point, it will continue. So the Rule 41 dismissal is not proper, and it shouldn't be considered when the court is deciding on the motion to transfer the case to Chancery Court.
Anything further from any other defendant? Mr. Corlew, in your motion, you had not asked your motion was a motion to dismiss or stay, and I believe it did not make the request for transfer. Am I correct on that?
Yes, Your Honor.
All right, and what's the reason for that?
Well, Your Honor, as executors of the estate, our concern was that we believe the plaintiffs were making a collateral attack on the will. And if the court agreed with our position, it should have dismissed the complaint, or at least stayed until the will contest were decided in Chancery Court. The amendment could possibly take out the challenge to the validity of the will, but if it were done, I mean, we would certainly want it done with the condition that there would be nothing that was tried in this court that affected the validity of our will. We're going to try the will in February 4th of next year, and our concern is defending the validity of the will.
All right, thank you. All right, let's move on to which defendant a motion to stay in discovery. Is that you?
That was our
motion,
Your Honor.
All right, let's, you don't have to reply on your ground, but just I want to give you a chance to say what you need to say and get a response.
I think I covered it, Your Honor, in our primary argument on the motion to dismiss, transfer, or stay.
All right. Does the plaintiff have any response to that brief comment?
Well, not much, Your Honor. Is obviously if the court allows us to dismiss the claim as being done and the complaint, then I think his motion will stay, but also be moved beyond. But we don't have any objections to standing discovery until the court rules. I'm pretty sure that there's going to be a time to rule.
Okay. Now we've got the plaintiff's motion to amend.
Yes, Your Honor.
And you can see.
Yeah, just very briefly, because I think I touched on it earlier. Our motion for leave to amend complaint deals with notice of dismissal of certain claims. There's an effort to streamline the issues and clear up some of the confusion of the issues in this case. We filed a motion for leave to amend the complaint to bring in defendant Richard Roberts and law Richard Roberts as Joe defendant 6 and 7 to substitute those, as well as to remove any negligence-based claims against perceived negligence-based claims against Dr. Michael Sarah, as well as to clean up the style of the complaint by removing the co-conservator out of the case, as well as dropping Parker, Irby, and the original lawsuit. When the lawsuit was filed, was Karen, as well as Karen on behalf of the minor child Parker, and many complaints will also remove Parker from the case because we dismissed the tortious interference with the inheritance cause of action. And also, I think as the court knows, according to Rule 15, leave to amend should be freely.
Response. And we can take the responses in the same order that we did the other.
Your Honor, on behalf of the defendants represented by us, I would say that this is pretty much subsumed in the argument we've already made. I think, bottom line, whether they're allowed to amend and bring in additional parties is a matter the Chancery Court could take up after the court transfers to the Chancery Court. One other thing I would say about the amendment is while they're dropping their tortious interference with right to inheritance, my question would be if amendments are freely given to take out claims, what's going to stop them 6 months from now from adding that one back in? And we're still back where we were when we started. There are no conditions on this other than the conditions they placed on their Rule 41 dismissal, which we again submit is improper.
So just so that I understand where you're coming from, are you saying substantively you don't have an objection to their filing, to their motion to leave to amend the complaint?
Substantively, I don't. Procedurally, I do. Okay? Because I think what it is an effort to get the court to approve by Rule 15 what they could not do under Rule 41.
I think I understand your distinction.
Please, the court, substantively, I would object to their filing a motion because, again, as the Supreme Court of Mississippi has clearly stated, venue is viewed at the time of the original complaint. If they want to file an amended complaint like a county, they're free to do so.
Your Honor, I'd just like to add that Rule 15 does allow amendments to be freely given when justice so requires, and here it's not clear why justice requires that these amendments be allowed. But I will say that under Rule 41A2, the court can allow dismissals under certain terms and conditions as the court deems proper, so as not to prejudice other parties. And so we would emphasize that if these dismissals are allowed, it should be with prejudice. I'd also like to add that again, their motion was not properly noticed. We got notice at 4:21 on Friday afternoon that their motion would be heard today. They filed no brief in support of their motion for leave to amend the complaint, and so we'd like to reserve the right to file any response to the arguments that they've made today.
Ms. Irby.
I just adopt everybody else's argument, Judge. Thank you.
All right.
Your Honor, if the amendment is allowed and plaintiffs later seek to amend to raise questions about the validity of the will, they again make a collateral attack on the will, we'll be right back in front of the court, moving to dismiss those claims. And I just might comment about the amendment complaining in of itself. It makes no distinction between any of the defendants. It doesn't make specific allegations against any of the defendants. And whether they're allowed to amend or not, I think all the defendants are going to be right back in front of the Honor making some of these same arguments against because they have not specified what the claim is for the various defendants. And like Mr. Williams pointed out, and Mr. Garrett, as this case progresses, these claims against persons who are serving in the capacity of conservator are going to have to be fleshed out, and there's going to be around motion practice to the extent to which those claims are against parties in their individual capacities. And that's not necessarily my dog in the hunt, but that's where we will, I think, be.
Mr. Harrison, reply.
Yes, Your Honor. First, we're seeking to amend the complaint to remove those causes of actions. If we had a draft complaint attached to our motion, that doesn't necessarily mean we can't make that amended complaint a little bit more specific if the court requires it, Your Honor. I do not think we'll be back here again arguing whether or not the new complaint has changed the court jurisdiction because the claims are equivalent to the claims. Furthermore, Your Honor, the claims that were alleged allows the plaintiff to have a trial by jury. The case is sent over to the Chancery Court, the plaintiff to be denied their right. So I think justice requires us to be able to amend the complaint such that the plaintiff will continue to have the right to a trial by jury.
All right. All right, those are the only motions I had in front of me this morning. Were there any motions that escaped my review? All right. I'll take it under advisement and get something sooner rather than later. And we'll adjourn at this time. You folks who are here for the next